The DOJ released a new memo, a very interesting memo, something that they did not want released for a very long time. It came out of the Mueller report saga, and you remember all this. They brought out Robert Mueller and they said, gosh, he's so brave and cunning and he's so intelligent and he's going to be able to go and just investigate Trump right out the wazoo. And we're going to be able to indict him and finally get rid of him. And the biggest thing was all about obstruction. Remember, they said Trump was obstructing the investigation and he was hiding documents and they were trying to get him on process crimes and all this crap. Well, we learned that there was this very interesting memo that was being floated around. You can see it here. It was drafted on March 24th, 2019. We are going to read through it. It's actually quite good. But it serves two purposes. Number one, to show that the entire Mueller report, the entire saga there was sort of much ado about nothing. When they referred this back over to the DOJ said, yeah, let's take a look at what you got. They looked it up. They said, yeah, no obstruction here. That's the conclusion. But it's also important because we are now taking a look at the same DOJ and we're asking ourselves, if they are going to be prosecuting Donald, on what basis would that be? And many people are saying obstruction is one of the charges. And we're seeing that sort of posture be set up as we speak, saying they sent letters, they sent subpoenas, they went over to Trump's residence and he met with the FBI, right? They're saying that he was sort of obstructing their ability to get certain documents, maybe even lying to FBI agents. We don't know. But all of this is being floated around. So what does this declination of prosecution mean for this current situation? They declined to prosecute him on Trump-Russia collusion hoax stuff. How does that carry over to today? Let's get some background on the saga. Business Insider assembled a lot of this for us. And here is what they tell us. The DOJ releases a secret memo recommended not charging Trump with obstruction of Mueller's Russia investigation. Right? Same thing is going on here. They're saying Trump is obstructing everything. This came out. It says the Justice Department on Wednesday released a once secret 2019 memo that recommended against charging Trump with obstruction of justice connected to the Russian interference in 2016. The 9-page memo, which we are going to read, is in response to a court order, right? The Justice Department didn't come out here and just say, you know, you guys should see this, America. You should see why there was no basis for charging him at all, because that's not what the narrative was, right? There are a lot of people, ex-FBI, ex-DOJ, screaming from the rooftops about how much of a criminal Donald Trump was. But there was no basis for it at all. That's why the DOJ did not want this out. It says it sheds additional light on one of the most climatic and controversial moments of Trump's presidency, whether he should face an indictment for trying to stop the Mueller probe, right? Obstruction. In their preparation of the memo, a pair of top Trump-appointed DOJ officials relied on a 400-page report from Mueller that summarized the findings. And so we're going to go through that memo right now. In fact, here it is. Written on March 24, 2019, this is the memo for the Attorney General, written from these two attorneys, Stephen Engel and Edward O'Callaghan. And this is a review of special counsel's report, Robert Mueller. He was investigating, remember all of this, Trump-Russia collusion, Mueller's going to be the end of Trump for like years, it felt like. Here is their final report, and they're sending this over to the Deputy Attorney General after Mueller sends this all back over. They say, okay, look, and this has been hidden for a long time. They say, okay, Mr. Deputy Attorney General, at your request, we have evaluated Mueller's report, Volume 2, about Russian interference into the 2016 election to determine whether the facts therein would support initiating or declining the prosecution of Trump under the principles of federal prosecution without any regard to his fact of being president. They're saying without the constitutional barrier under Article 2, because as the president, you have all sorts of presidential privileges and executive privileges. So they're writing this memo, sort of setting that issue aside. They're saying without regard to any of the constitutional barriers to prosecution that exist, right? They're just saying, look, if we just took Trump as sort of a generic, everyday layman citizen and applied the facts to him, could we charge him with obstruction? Forget about the Article 2 stuff as president. Forget it. So they say, okay. They write, over the course of the special counsel's investigation, we have previously discussed these issues within the department, ourselves, the Attorney General, and many others. This is the conclusion of our work. For the reasons stated below, we conclude that the evidence described in Volume 2 of the report is not, in our judgment, sufficient to support a conclusion beyond a reasonable doubt that the president violated the obstruction of justice statutes. Okay, it's a declination. It's a non-starter. This is of the basis for why they decided not to indict him. They say it just doesn't meet the statutory requirements. In addition, we believe that the certain conduct examined by special counsel Mueller could not, as a matter of law, support an obstruction charge under the circumstances. Accordingly, were there no constitutional barrier, right? So we can now sort of bring that issue back in. We would recommend, under the principles of federal prosecution, that you decline to commence such a prosecution, right? Can you see why they didn't want all of this out now? Because it's sort of supporting the opposite narrative of theirs. Back then, they were saying, Trump's a criminal. I mean, he should be indicted every day. Every day you turn, it's still every day. Michael Cohen is still on CNN going, I've got the goods any day now. I'm from New York and I'm going to, all of it. This says, no, it should be a declination. It's like not even close. We wouldn't even charge him as a regular citizen, let alone under any of the, thinking about the constitutional barriers as his executive privilege comes into play. So they say the department should reach a conclusion on whether prosecution is warranted based on the findings in the volume of Mueller's report. They say special counsel reached no conclusion as to whether Trump violated any criminal law. Special counsel considered a bunch of stuff like justice manual standards and all this. And they write, although Mueller declined to reach a conclusion, we do think that the department should reach a judgment on this matter. And they write, we recommend that you examine the report to come to a conclusion. And they add this into that conversation, right? They say prosecution would not be warranted based on the findings in the report. Based on the evidence described in the legal theories articulated, we believe prosecution would not be warranted wholly apart from constitutional considerations. We've got several reasons why. Subsection A. They go back to the fundamental principles of federal prosecution, saying there's a lot of issues that might pop up in this thing. If we apply the justice manual to our issues at stake here, we see that a person's conduct under scrutiny is not a federal offense or admissible evidence. Then they say the prosecution should be declined. You see that there. They say there's no precedent for obstruction on similar cases. To our knowledge, Mueller's investigation of potential obstruction is not similar to any reported case the department has previously charged. We've never seen any case like this. You want to charge him for this, and we've never done anything quite like that. The report identifies no obstruction case that the department has pursued under any remotely similar circumstances. We have not identified any either. Of course, any investigation concerning the president would be exceptional, obviously, but the president is hardly the only public official under scrutiny here. The special counsel's obstruction theory would not only be novel, but it would be based on his own analysis. It would be unusual because they're saying in volume 1 that there wasn't any sufficient evidence to charge anybody in Trump's campaign. They say, given the conclusion, the evidence does not establish that a crime or criminal conspiracy even was attempted or occurred. So what they're saying, how can you have obstruction if there was no underlying offense? There's no evidence, according to volume 1 by Mueller, that there was any nefarious activity from Trump. So they're saying, how is he obstructing an investigation into a non-crime? They say it would be rare for federal prosecutors to bring an obstruction prosecution that did not itself arise out of a proceeding related to a separate crime. You're investigating somebody, they're obstructing your investigation, but there's investigation into nothing? They say, moreover, much of the president's obstructive conduct amounted to attempts to modify the process under which the investigation progressed rather than impair or alter evidence that would impact the ability to obtain or develop evidence, right? So it's just sort of deviating, maneuvering the investigation. It's not deterring it. They write, the special counsel's report cites over a dozen federal obstruction decisions in this report, yet nearly every one, the charged conduct involved inherently wrongful acts to things like destroying evidence, creating false evidence, tampering with witnesses, and other things. And they're saying the president's conduct just doesn't meet that. They say the report does not identify any actions rising to obstruction of justice, right? So some sort of physical conduct. They write, we've reviewed all of Volume 2. We don't identify any sufficient evidence to prove any criminal offense beyond a reasonable doubt. Although the Volume 2 makes no conclusions about his conduct, it adopts expansive language. The report suggests the president's exercise of executive discretion for any improper reason, including the prevention of impersonal embarrassment, could constitute obstruction of justice. But they say, as we've discussed, we do not subscribe to such a reading of those statutes. Okay, so these are two lawyers disagreeing. Somebody says obstruction of justice includes improper purpose, and they're saying improper purpose includes personal embarrassment. So you see how these things are sort of nested. Obstruction of justice is this broad category. Obstruction includes doing things for improper purpose. Improper purpose means doing things to avoid personal embarrassment. That's one version. They're saying here, no, we don't think that at all. Personal embarrassment is a totally proper purpose. You can do whatever. It's perfectly reasonable. No reported cases come close to upholding a conviction of such breadth, and a line of Supreme Court precedent, including other cases, weighs heavily in favor of objectivity and certainty in federal law. Therefore, we don't agree with your finding here, and saying that Volume 2 does not establish those offenses at all. They go through all the different areas of conduct. Let's fast forward through some of this. They detail Trump's specific actions and his conduct related to witnesses, right? And all of this are different sort of points of analysis that you can compare and contrast with the current situation. They're saying Trump requesting that McGahn deny newspaper accounts and all of this. The president vehemently denying that he wanted to fire special counsel and all that stuff, right? All of that is within the purview of the president's authority. He can make those decisions. He can have the ability to have those conversations. That does not automatically make it, illegal. So they say recommendation here signed off on March 24, 2019. After all of this analysis, they say, we recommend that you conclude that under the principles of federal prosecution, the evidence developed during the special counsel investigation is not sufficient to establish that the president committed obstruction of justice. And that is very much analogous to what's happening in the Mar-a-Lago raid, saying Trump was, battling with the FBI back and forth, having a lot of conversations with them. Same thing happened here. Same thing, almost exact parallel to what happened in the Mueller investigation. Trump sort of fighting with them, negotiating terms about scheduling interviews and witnesses and turning over documents. Same exact thing. And they said here, prosecution was not warranted. When you go back through the case law, they've got all the bullet points out. But that same conversation is now fresh in the minds of the prosecutors out of the DOJ. They're saying Trump is obstructing the investigation. And Lindsey Graham is a senator who remembers a lot of the Mueller investigation and how all of this unfolded. Here is Lindsey Graham, who is defending Donald Trump. He used to be a big advocate. He is now saying that he does not trust the FBI. He does not trust the intelligence communities and what they are doing in this investigation.
So this idea of drip, drip, drip 80 days before an election needs to stop. We need to see the affidavit.
The material, they say boxes of over 100 documents, classifications marking over 700 pages. Do you not believe those numbers?
I read about the Mueller investigation every week, right? In the New York Times and the Washington Post.
We all did.
Nobody told me that they altered information to the FISA court. Nobody told me that they had information that the entire basis for the Carter Page warrant was a bunch of hearsay and bar talk. So no, I don't trust these people. What I want to do is see the affidavit. This is a raid on the former president of the United States' personal home,
right,
80 days before an election, and you're supposed to I'm supposed to trust the New York Times and the Washington Post? Hell no.
Right. May 10th.
Wow. So Lindsey Graham now joining Team Trump. His moral outrage is really shining through, and rightfully so. I think he understands the consequences of this raid, and he's demanding to know answers. There were more conversations about the Gang of Eight, senators, Republicans, Democrats, House representatives, many people who want to get their hands on this affidavit. because they're trying to decipher what is going on here. Is this really a potential end of America if Donald Trump gets reelected? Is he really selling secrets to the Saudis or something? Don't know. Or does he just have some leftover library books that some angry librarian wants back, even though they're Trump's books and Trump built the library? Here's Jared Kushner talking about the peculiarities of Donald Trump. Kushner worked for Trump for a long time, and now he's got a book to sell. And so now he's out here explaining his opinion about, well, his take on Mar-a-Lago.
Did he make a mistake by taking that material to Florida?
Like I said, I'm not familiar with what was in the boxes, but I think President Trump, he governed in a very peculiar way, and he, when he had his documents, I'm assuming he did what he thought was appropriate.
When you wrote your book, did you have any difficulty working with the archivist and trying to get documents to, if you wanted to refer back to something?
No, we were able to work through it. We didn't really have to rely on the archivist. We knew I decided to do this in December as I was leaving, and so I was able to make sure that we got sign-offs for any material that I needed.
Jared Kushner saying that Donald Trump has a very peculiar way of running things, and he might have just wanted the documents. He might have just said, yeah, that letter is nice, and I'd like to hang on to that, and the archivist said, those are my library books. And as we covered yesterday, there was this whole litany, this whole sort of chain of events, this domino sequence that started as soon as Joe Biden waived executive privilege. National Archives sent this over to their sort of investigatory body when they were not happy with what they got, over to the DOJ, DOJ to the FBI, and the rest is history. So new DOJ memo has been released after a long time, years of them fighting to keep it sealed, seems to show that back then there was no basis for charges for obstruction of justice for Donald Trump, much the same as now. And we, of course, will continue to cover